on industry, science, and technology. Pursuant to the order of reference of Saturday, April 11th, the committee is meeting for the purpose of receiving evidence concerning matters related to the government's response to the COVID-19 pandemic. Today's meeting is taking place by video conference, and the proceedings will be made available via the House of Commons website. I'd like to remind members and witnesses, before speaking, please wait until I recognize you by name. When you're ready to speak, please unmute your microphone and then return to mute when you are finished speaking. When speaking, please speak slowly and clearly so that the translators can do their work. As is my normal practice, I will hold up a yellow card for when you have 30 seconds left in your intervention, and I will hold up a red card for when your time for questions has expired. Today we have two panels, so separated. The first panel we have with us today from the Office of the Privacy Commissioner of Canada, Mr. Daniel Terrien, Privacy Commissioner, Mr. Gregory Smolinek, Deputy Commissioner, and Martine Turcotte, Director, Technology Technology Analysis Directorate. And before we start with the witnesses, I believe Mr. Massé would like to speak. Go ahead, Mr. Massé.
Yes, thank you, Madam Chair. Just a quick point of order to committee business. And I'd like to move the following motion to continue our work with fraud protection in Canada. And the motion to be read is that all evidence and documentation received in relation to the subject matter of fraud calls during the committee's study of the Canadian response to the COVID-19 pandemic be also deemed received by the committee in the context of a study on fraud calls in Canada. This would allow us to fold in the work that we had fraud to our previous meetings, which is relevant. And I know that there's been discussions with the parties to hopefully proceed in this fashion. So I'd move the motion and would ask for consent for that to pass, please.
So we have a motion on the floor. Yes, Madame.
Just on this point of order, just because I'm a stickler for procedure, while I support Mr. Massé's motion, it is being moved on a point of order, and you would require unanimous consent for this to be moved. I believe I'm looking at the clerk in the gallery view. So I would just want him to rule on that so that we can make sure that we're setting precedent appropriately in this format. I have no problem with the motion, and I would also support unanimous consent for it to be moved on a point of order, but I just want to do things by the book.
So actually, Madame Rempel-Garner, I was just about to let him know that you cannot put a motion forward on a point of order. So you jumped ahead of me, but thank you. We're on the same page on that one. So with that, we will just I will rule it that I understand that he was going to just table the motion, and that just adding on that point of order was an addition. So I will rule it acceptable. With that, I'll open the floor to debate if there is any.
I think, and I'm looking at the clerk, Madame Chair, just on a point of order with regard to procedure. Perhaps I think Mr. Massé should just seek unanimous consent for this to be moved on the point of order, and then we have everything good to go.
I verified with the clerk, and it's actually the chair that rules, not the clerk, and that he should have just said not have included the words point of order. But with that, we do have the motion on the floor. I just want to double check. Is there any debate? Otherwise, we will go to recorded division. I believe I see an analyst waving at me.
I would just request some clarification from Mr. Massé. You said evidence regarding fraud calls that were received on May 20. There was much evidence on May 20 that were not fraud calls per se, but COVID-19 related fraud, some of which was delivered through calls, many through text or web. So is it specifically just fraud calls or just all COVID-19 related fraud?
Just COVID-related fraud. It didn't. I don't believe I actually set a date. If I did, I apologize. But it's related to the evidence and testimony, and I can leave that to yourselves to determine. But it's the evidence from the special hearings folded into the previous work that we did.
Thank you, Mr. Massé, for clarification. Seeing no debate at this time, we will go to a recorded vote. I turn the mic over to the chair, to the clerk.
Okay, the question is on Mr. Massé's motion to include the fraud study information from our COVID-19 study into the fraud call study. So, Mr. Erskine-Smith.
Yes.
Ms. Lambropoulos.
Yes.
Mr. Johari.
Yes.
Mr. Assassi. Mr. Assassi.
Yes.
Mr. Longfield.
Yes.
Ms. Rempel-Garner.
Yes.
Mr. Dreeshen.
Yes.
Ms. Gray.
Yes.
Mr. Patzer.
Yes.
Monsieur Lemieux. Mr. Massey.
We.
So that's 11 for, against.
I declare the motion carried. Thank you very much, Mr. Massey. We will now go with our witness testimony. So, Mr. Terrien, you have 7 minutes to present.
Merci, Madame la Présidente.
Thank you very much, Madam Chair. Is it working for the language? All right. Thank you very much, Madam Chair and committee members, for your invitation to discuss tracing applications, which is one of the approaches being studied in Canada and elsewhere to ensure a safe return to a more normal life. Please note that the expression tracing applications is used in public speech to describe various mobile applications as public health tools. Some are designed for conducting true contact tracing, while others have the ultimate goal of informing users and giving them advice based on their level of risk. Now, I'm going to address protecting both public health and privacy. During this public health crisis due to COVID-19, the health and safety of Canadians is a key concern. It is natural for governments and public health authorities to try to find ways, including technological means, to better understand and control the spread of the coronavirus. In this context, the Office of the Commissioner has suggested a flexible and contextual approach in its enforcement of privacy laws. We strongly believe that it is possible to use technology to protect both public health and privacy. Technology in itself is neither good nor bad. Everything depends on how it is designed, used, and regulated. When properly designed, tracing applications could achieve both objectives simultaneously, in terms of public health and the protection of rights. If implemented inappropriately, they could lead to surveillance by governments or businesses that exceeds public health needs and is therefore a violation of our fundamental rights.
English. I do not have the language button on my screen. I have a microphone and a camera, but no indication of language. Does that work, even though I'm in English now?
I believe it might be on the top right, Monsieur Terrien. There should be 3 dots. Can we just get a verification that the translation is working?
Yes, just a second. No. So if I speak in English, does it work well?
Monsieur Terrien, can you try to speak a few more words in English?
Yes. So I'm about to speak about the importance of the design. No?
Unfortunately, it's actually the translation is not working. If you could hold one moment, I've stopped the clock. Monsieur Terrien, we're just checking with IT because you're not switched over to the English, that when you do speak English, the translation does not come through. So we cannot proceed until we can verify that. If you could hold one moment.
Yes.
With that, I'm going to actually suspend for one moment so we can get IT to work with you. One moment.
continue, please, in French. I don't have the French version of my speech. What I could suggest is that my colleague, Mr. Smolinek, reads the end of the speech in English, and then I will answer the questions in French, no matter what language they're asked in. All right, that's just fine. Thank you.
Good afternoon. Can you hear me? Is the translation all right? Yes, I'll proceed there then. Following from the Commissioner's opening remarks, appropriate design of technologies, such as tracing applications, depend on respect for some key privacy principles recommended in the OPC's framework to assess privacy impactful initiatives in response to COVID-19, and in a joint statement by federal, provincial, and territorial privacy commissioners on contact tracing applications. In the interest of time, we will focus here on 6 of these principles. First, purpose limitation. Personal information collected through tracing applications should be used to protect defined public health purposes and for no other purpose. Second, these applications should be justified as necessary and proportionate, and therefore be science-based, necessary for specific purpose, tailored to that purpose, and likely to be effective. Third, there must be a clear legal basis for the use of these applications, and use should be voluntary, as this is important to ensure citizens' trust. Use should therefore be consent-based, and consent must be meaningful. Fourth, these exceptional measures should be time-limited. Any personal information collected during this period should be destroyed when the crisis ends and the applications decommissioned. Fifth, transparency. Governments should be clear about the basis and the terms applicable to these applications. Privacy impact assessments or meaningful privacy analysis should be completed, reviewed by privacy commissioners, and a plain language summary published proactively. Sixth, accountability. Governments and companies should be accountable for how personal information will be collected, used, disclosed, and secured. Oversight by independent third parties, such as privacy commissioners, would enhance citizens' trust. While governments have stressed the importance of privacy in the design of tracing applications, several of the principles we have mentioned are not currently legal requirements in our 2 federal privacy laws. So, for instance, nothing currently prevents a company from proposing an app that is not evidence-based and use the information for commercial purposes unrelated to health protection, provided consent is obtained, often in incomprehensible terms. A government could partner with such a company. The current health crisis has made clear that technologies can play a very useful role in making essential activities safe. This meaning is about contact tracing, but potential benefits are much wider. For instance, let us think about virtual medicine or e-education. What we need, more urgently than ever, are laws that allow technologies to produce benefits in the public interest without creating risks that fundamental rights, such as privacy, will be violated. And because of the growing role of public-private partnerships in addressing situations such as the COVID crisis, we need common principles enshrined in public sector and private sector laws. Thank you. That concludes our statement.
Thank you very much. And with that, we will move to our rounds of questions. Our first round of questions of 6 minutes goes to MP Rempel-Garner. You have the floor for 6 minutes.
Thank you very much to our witnesses, and thank you for your work in protecting Canadians during this time of crisis. I appreciate the framework that you put out proactively with regard to privacy related to contact tracing. So I'll start my questions with Monsieur Terrien. Are you absolutely confident that Canada's current privacy laws would protect Canadians if a privacy breach occurred in a contact tracing app?
No, I am not. The my office has been talking for several years now about the fact that our legal framework needs to be modernized and strengthened. And the current crisis, I would say, clearly shows that there will be a need to accelerate the technological revolution that was already at play before COVID. And this acceleration requires an even stronger legal framework.
Thank you. Has any federal government department actively engaged your office to work directly with regard to rectifying these laws ahead of a contact tracing app being, quote, strongly recommended, as the Prime Minister said in a press conference last week?
Je devrais peut-être répondre en français à cause du problème de...
I should perhaps respond in French.
Alors, on n'a pas été consulté par le gouvernement au sujet.
We were not consulted by the government with respect to this. There was a contact that was made with people who it was the group called Mila that was put in contact with us. And we were able to obtain advice with respect to their applications working with the federal legislation, but we've heard nothing from the government with respect to giving advice to the government on an application per se with that. Which doesn't mean that the government hasn't proceeded.
You any indication they would be, or they intend to accept the framework that you have recommended with regard to privacy laws or a privacy framework needed prior to a contact tracing app being recommended by the federal government?
Dans le cadre des applications de traçage, mais au-delà, on a eu des conversations avec...
We've had conversations with the government, with government officials. Officials indicated to us that they wish to work with the framework, but at the same time, they reminded us that our assessment framework goes beyond the present act in certain areas, which is true. And in the end, the government should respect the law, which means that it might be possible that some principles will not be enforced because they go beyond what is set out in the Act.
Spoken that Canada's privacy law.
Étant donné que vous avez dit que les vies...
Sorry, I'm just getting Can we just pause for a sec? I'm getting French interpretation while I'm speaking. I'm getting my own French interpretation, Madame Chair.
We've paused the mic one moment. Sorry, the countdown. Madame Rempel-Gardner, are you on the English channel or on the floor?
I'm on the English channel.
Thank you. We're going to try that again. Si vous pouvez continuer.
Merci.
If you'd like to continue.
Given that you've spoken out, Mr. Therrien, about the lack of strength in Canada's privacy laws as it stands, do you feel that it would be accurate to say that if a government strongly recommends the use of any contact tracing application at present, that Canadians would be asked to be choosing between their privacy and public health outcomes?
I would not, je n'irais pas aussi loin que ça. Je dirais,
I wouldn't go that far. I would think that it's high time for the context of those laws to be improved, particularly in the situation we're in now. But if an application is properly designed with privacy principles in mind, it is conceivable that the application could protect privacy for Canadians. So we would like to see the legislation changed, but...
So how confident are you right now, given that, again, the Prime Minister has said that he's about to strongly recommend an application or a contact tracing application? How confident are you right now that any application that's developed would be delivered in that ideal world that you just spoke about with regard to stronger legislation for privacy?
Je pense qu'il est peut-être un peu prématuré.
I think it's a little bit premature to confirm that. We have to wait and see how the application is designed. And once we see what the design of the app is, then we would be able to speak to what the government has done.
That the government hasn't contacted you proactively with regard to this? Like, one would think that they should be proactively working with your office if the design, as you just put it, is contingent upon privacy laws being respected in Canada? Or privacy laws being respected are contingent upon the design?
Alors, on a offert nos services.
Well, we offer a service. It would be preferable for the government to approach us or to already have approached us with the way in which the app is designed. Various officials and ministers have spoken about the involvement of the provinces on a variety of times. Perhaps the government is not ready to consult us yet, but to date...
Monsieur Terrien, c'est tout le temps qu'on a.
I'm so sorry, Mr. Terrien. This is all the time we have for your questioning.
P. Erskine Smith, you have the floor for 6 minutes.
Thanks very much, Commissioner. It's very good to see you again. I, too, believe that the government should proactively consult with you in not only the development of these applications, but certainly as they are leading the way in partnership with provinces in the development of these applications. I think it's really important. I want to ask about the principles that you espouse. When I go down the list, I agree with almost every single one. And so when I look to purpose limitation, of course, that makes sense. When I look to the collection of data being necessary and proportionate to the matter at hand, that, of course, should be a key restriction. A clear legal basis, I agree with, and I want to get back to that. Time limitation, agree. Transparency, accountability, oversight. I think your office should be involved in that oversight. When we talk about a clear legal basis, you in your joint statement with other privacy commissioners, and then again here today, have indicated that it should be consent-based and entirely voluntary. I wonder what you think about opt-in versus opt-out, and would opt-out be sufficient in the circumstances where, if we didn't have an opt-out system and we were only looking at opt-in, we couldn't get the adoption rate necessary for the system to work at all?
So to be clear, you're correctly putting in your question the question of legal basis and consent and voluntariness. Under federal private sector law, et encore une fois, je vais changer en français peut-être.
Once again, I'll change into French. Maybe it isn't necessary at this point, but it seems to me that it's better for interpretation if I speak French. Consent is necessary, but if the application is used by the provincial governments, for example, by the provincial health authorities, it is possible that that consent would not be legally required. The essential point that the commissioner, myself, and my provincial colleagues have to deal with is this: consent has to be voluntary, and therefore you have to promote the people's trust in the use. People have to trust in an application. There should be consent, therefore.
I agree that there needs to be trust, and I think it should be privacy preserving in every possible way. And I agree with the principles you put forward. And I would say also, as it relates to protocols, whether it is the DP3T or whether it is the D3PT or whether it is the TCN protocol, I do think there are other ways we can preserve privacy. I do wonder, though, in your statement, you say de-identified or aggregate data should be used whenever possible, unless it will not achieve the defined purpose. And if I take that same approach to say we're going to abide by these ideas unless we have to say, on balance, in the best interests of the public interest overall, the app won't achieve the defined purpose if we have an opt-in system only, and if instead an opt-out system would get the adoption rates we need, would you be opposed to that?
I'm not sure how that works in practice.
I asked Google, as an example, I asked Google at our committee the other day if the app could be put on individuals' phones by way of an OS update, and people would have a choice as to whether to do that or not. But it would be effectively automatic, and then people could choose to opt out. That could be one way of doing it.
Potentiellement, mais
potentially, yes, but people should have the choice of traveling and moving around in society without having to hang on to a telephone. In practice, if not in law, consent is the voluntary characteristic here in terms of the use of the app and consent.
Because I only have a few minutes left, can you give our committee an update on your efforts to take Facebook to court?
Yes, I'll have to be careful, obviously, because we are before the federal court on this issue. Après le rapport d'enquête qu'on a.
After the inquiry in the spring of 2019, and at the beginning of 2020, we referred the issue to the federal court and asked the court if it could order Facebook to comply with our recommendations. Because, as you know, Facebook, to constrain Facebook to accept our recommendations. So, as I said, we addressed the federal court in 2020. Facebook brought in an application to quash our request to the federal court. The federal court, it was seeking to have the federal court not ask Facebook to comply with federal regulations. So it is still before the courts.
I previously indicated that I thought Facebook was breaking the law. They denied it, and turns out that they did, in your view, certainly. And I think it will be the view of the federal court. I take the same view of Clearview AI, and I encourage you to bring the full efforts of your office brought to bear against Clearview AI, who have clearly broken the law of Canada in relation to our privacy laws. Thanks very much.
Thank you.
Thank you very much. Our next round of questions, notre prochain tour, c'est Madame.
Next turn, Madame Gaudreau, you have the floor for 6 minutes. Yes, well, hello, Mr. Terrien. I'm very happy to see you today. The sound's good? Okay. I am very much concerned about an issue that we have in terms of public health and privacy protection. You know that I, too, am part of the committee that deals with the protection of privacy in Canada. What I'm concerned about is this. Businesses can actually propose new applications. You know that there are certain means to aggregate data, and this being the case, what precisely is most urgent here from a legal perspective when you are looking at this case? Potentially. I'm sorry, Mr. Terrien. I didn't hear the beginning of your sentence. you can proceed in two. Do you hear me right now? Yes. We can proceed in the following way. Looking at it in two steps. If an application is well designed, it can work. This being said, there are groups like CFAR, which is a research institute that was mandated by Dr. Demers, who is the chief scientist for the Prime Minister, and that group is looking at specific laws related for tracing contacts. That's being worked on with our provincial colleagues, where their federal provincial commissioners would have a watchdog role to play. So that it would be good to be able to modify the legislation, but I'm not sure it would be necessary to do so immediately. But in a very near future, for tracing purposes and also for the purposes of other technological use, and the effect that has on society, increasingly telework and so on, it's very important and is being used more in the context of COVID. Telemedicine is very important because there are confidential conversations between doctors and patients on telemedicine. So we have to be able to protect that. We have to, in the very near future, find ways of protecting those conversations. And if you are talking about moving towards a digital identity in the context of protecting society. You have mentioned this already when you have 3 out of 37 million Canadians have had their personal information stolen or disappear, and who knows if it's being used for fraudulent purposes. But maybe we should just go headlong into drafting legislation. What do you think? Well, it's been years now that we have been asking for the Federal Act to be amended, and certainly it is even more important now. It's even more urgent in the context of the growing importance of technology. You talk about identifying the digital identity. In the past, that was founded on the SIN number, as simple as that is not very well protected by Canadians.
For legislative reform, we would have to think about this. We would have to look at the modern ways of protecting identity. It could be based on biometrics, and it also raises some privacy questions. However, this is still something that we need to talk about. Very well. Now I have another question about what's happening with Statistics Canada. They're measuring confidence levels, and right now our confidence level regarding data management is very low. What do you think of the results that could allow us to make quick choices about what's going to be brought out in July for Quebecers and Canadians? Are you talking about the investigation we did on StatsCan? No, I'm talking about the investigation that was announced recently, and that is about people's trust levels. I'm not sure of what you're talking about, but I would say that one of the things that COVID has shown is that the private sector and the public sector are collaborating, and that is not necessarily a bad thing. They are working together to share data. For example, the federal government as well as the provinces are discussing with developers like Google and Apple. So there could be collaboration between the public and private sector to manage the data. That brings us to the following conclusion. since the data will be traveling between the public and the private sectors, we would have to modify not only the private sector rules, which have been in discussion for many years now, but we would also have to change the rules for the private sector. Thank you. That is all the time that you had.
Let's say you have 6 minutes.
Thank you, Madam Chair. And again, thank you to you and the committee for the motion passed earlier to help Canadians fight fraud. It's much appreciated. My first question will gonna start with 1983 was when the Privacy Act was passed, and we kind of created our current regime. We had floppy disks, we had mostly paper files, all those things. There hasn't been a major modification to the Act. There's been 2 attempts, I think in 2010, 2011, where there was tabled legislation in Parliament that never passed. And so we're dealing with very much an antiquated process to protect the public. I believe the work that the Office of the Privacy Commission has done since I've been a member of Parliament has been terrific. It's been important for citizen rights and also important for the economy. I would argue it's actually strengthened investment in some sectors and newer technologies. My question at the first is that should this contact tracing be rolled out, is there a way to differentiate where the exact strength and weaknesses per an application could be from your powers? And then second to that, would you be in support of a process Parliament could reconvene quickly to pass legislation to give specific empowerment to protect people for data contact tracing? Would that be something that would be considerable as opposed to living with the weaknesses of the current legislation?
Well, de toute évidence,
Obviously, we would much prefer to see laws modified, and we could mention public and private transfers. There are transfers between the provinces and the federal, but this is a very complex matter. If we could have common ground for all stakeholders, it would be very useful to manage data transfers while protecting privacy. The federal commissioner could intervene if a federal department used data, but this is not very easy. The federal government wants to support measures that would be enabled by the provinces. If the federal government or if a federal department is not collecting personal data, the commissioner wouldn't have much say. However, provincial authorities would be collecting the data and using it to fight COVID-19. And the provincial commissioners would then have jurisdiction to act.
One of the things you did was at least outline to us some major points. And one weakness that I'm concerned about as well, and like to get your opinion on this, is if we did contact tracing, it seems like a lifetime ago, but when Paul Martin moved to outsource the Canada Census to Lockheed Martin, which was done, one of the problems that we faced and fought a national campaign to reverse was the data to stay in Canada for assimilation, because it was going to be shipped to Minneapolis, I believe, at that time. And under the U.S. Patriot Act, it became vulnerable. Do you have any concerns about foreign applications and movement of data and any contact tracing? Because there also have been considerable discussions internationally, including France most recently with contact tracing, and even everything from surveillance technologies, but also you could even have consumer exposure. So how do you feel about the data and information and security staying in Canadians' hands?
Je pense que
I think at the beginning, my answer would first be that recently Canada has reached agreements, commercial agreements, to have rules about localization data in Canada. There are some national companies that have servers in Canada, and in practice, that could be a solution. This is a very complex matter. commercial agreements are an important factor, and they could also limit Canada's ability to ensure that data remains within the country. But for foreign companies, if they had a role to play, if the principles that we are proposing are respected, if, for example, Google and Apple decided that they're not interested in collecting personal data, then the fact that the data is traveling outside of Canada, if privacy rules are respected, then that's not an issue. If our principles are followed, there would be an issue regarding private data, but it would be disadvantageous for companies not to follow the law. The law allows companies and the government to not follow some of our principles.
And real quickly, the problem with your current circumstances is similar to Facebook. You have to go to court. You have very limited tools to enforce breaches and bad conduct. Is that not correct?
C'est certainement une partie de la difficulté, et encore une fois.
Yes. Once again, our legal provisions do not give us any tools to regulate personal data in contact tracing software.
We will now go to MP Patzer for 5 minutes, and a quick reminder, when you see this, you have 30 seconds. This is the end of your intervention. Merci.
Thank you.
So quick question right off the top here. Would it not be a violation of personal property rights to force an opt-out system for contact tracing, especially since it requires a forced update on our phones, which is our personal property, not the government's?
Alors, encore une fois.
Once again, I'm not sure that I understand how, in practice, this type of measure would be applied. I understand that companies that are responsible for some platforms could offer modifications. Normally, these changes can be accepted or refused by the users. This would mean that the device wouldn't work unless consent is given. So I don't really understand how we would reach implicit consent.
Yeah, and I mean, again, it's just the whole forcing of an update onto somebody's phone so it would automatically have the update. I mean, I get the consent piece, but in order for it to work in practice, we would basically have to force the system onto people's devices. Moving on, recently an epidemiologist and associate professor at the University of Ottawa stated, public health issues take precedence over individual rights issues. My question would be, does your office share this belief that public health trumps individual rights?
Non, nous croyons que les deux.
No, we believe that both objectives are very important. We obviously understand the importance of protecting public health personal data right now, but we don't think that one of them should be above the other. It is completely possible to protect both things at once.
Is operating under the assumption, though, that public health takes precedence over individual rights?
Ce n'est pas ce que j'entends de la.
That's not what I'm hearing from ministers and public servants. What I'm hearing from them is that privacy is very important and it is crucial, according to some. So I am not saying that, well, I am not questioning their intent, but I think that it is possible for some actors, like companies, to ignore the principles that we are putting forward. And in that case, they would not be protecting privacy. I think that currently they have good intentions. We are talking about how this would look in practice, and this is why we are putting forward suggestions for the technology that would be created.
Okay, thank you for that. Appreciate it. Also, so has the government previously shown that they are willing to fully cooperate with your office and its investigations?
Je ramènerais ça.
Departments cooperate with our investigations. They don't always agree with us. But once again, we don't have any powers to compel some behaviors from a company or an organization. So usually we collaborate, but sometimes, frequently, departments disagree with our recommendations.
Qui nous ramène à la déficience.
This brings us back to the missing aspects of our judicial system. No one would be able to force anyone to make some changes to protect privacy.
Okay, and then we've got about 40 seconds left here. So on March 20th, your office issued guidance on privacy and the COVID-19 outbreak and stated that you will, quote, protect the privacy of Canadians while adopting a flexible and contextual approach to its application of the law. So what does the commissioner mean by a flexible and contextual approach?
D'une part, dans nos activités.
On the one hand, for control and for enacting our laws, we have less contacts, and departments have more time to apply some of the laws. Some laws are interpreted more flexibly in this current context.
And our next round of questions goes to MP Longfield. You have 5 minutes.
Thank you. And thank you, Mr. Theriault, for being with us today. It's very important testimony you're giving us. I'm looking at the accountability principle, and in it, it mentions if effectiveness of the application cannot be demonstrated, it should be decommissioned and any personal information collected should be destroyed. The question of effectiveness, I spoke with an epidemiologist today who was saying because of the long gestation period of this virus, that it's very hard to determine whether tracing would be effective. How would we look at effectiveness of tracing as an example?
C'est une excellente question.
That's an excellent question. I believe that no one would say that tracing applications are a silver bullet. Neither people in charge of privacy or public health, but it is conceivable that tracing applications might contribute to the solution, contribute to the identification of individuals suffering from COVID, and then we could use more traditional means to contact these people, to provide advice, to ask them to stay home, etc. So these applications won't be the complete solution, but they could contribute. All of this in a context where we're facing a completely new phenomenon. So when privacy principles say that we must be able to demonstrate the effectiveness of a measure, it doesn't mean that we have to demonstrate absolutely that the measure will be absolutely effective. Here again, we would have a contextual, flexible approach. What we want is that there be basic scientific proof proving that the measure could be effective, added on to other measures.
And you mentioned public health, and of course that's a concern with federal, provincial jurisdictions and also transnational jurisdictions as people travel around the world. I spoke with the Homewood Research Institute this week, and we talked about the mental health apps that are out there, and they've now developed a framework for measuring effectiveness of mental health apps, but are concerned about data and the protection of data, particularly on apps that may have been developed in other countries. Do we have agreements internationally, or do we work with foreign developed applications that would then have to meet Canadian regulations in order to be used in Canada? How do we share information across jurisdictions, either provincially or internationally?
La protection des données.
The protection of data on telemedicine or mental health services, well, that's one of the reasons why we're of the view that we have to change the legal framework as quickly as possible, which does not mean that there is no legislation in force at present. There are laws in place, but they're very defective or deficient, and I am not aware of important protection measures with regard to the exchange of information between patients and their doctor.
And I think in terms of our judiciary, they would be interpreting laws as context changes, and those interpretations would then be applied to future rulings as well.
Oui, c'est une.
Yes. That's a legal interpretation method that is used. You take into account the context and the measure itself.
Within my last minute, I'm looking at, we're developing the digital strategy, the digital charter. You've been working extensively, I'm assuming, with the industry, science, technology groups around digital transitions. Is it fair to say that we're into that process, or is that process yet to begin? And would that process help us in terms of what you're now working on in the COVID-19 cases?
Alors,
we've had several discussions with the government, for example, the Department of Innovation, etc., dealing with the digital strategy, but these meetings are very irregular. We agree on the objective, which is to better use data, to have digital government fully functional, but no, we're not really consulted on these matters, and I would bring you back to the fact that the laws must be modernized in order that we truly benefit from digital government. Thank you very much.
Next round of questions goes to MP Dreeshen. You have 5 minutes.
Well, thank you very much, Madam Chair. We're certainly living in unprecedented times, and that's true not only because of the impact of COVID-19 on the economy, but this pandemic has opened the door to unprecedented intrusion by governments into both the personal affairs and the personal information of all Canadians. Mr. Therrien, you mentioned in your remarks that what we need more urgently than ever are laws that allow technologies to produce benefits in the public interest without creating risks that fundamental rights such as privacy will be violated. So, as you know, Parliament is essentially shut down at the moment. So who knows when it's going to return to the role of dealing with essential legislation, and for that matter, why would it when it's getting away with government by press conferences? Yet, as had been noted, the current crisis heightens the need for law reform. So what are the dangers of moving forward with technologies like contact tracing if stronger laws are not in place?
The main risk, the main danger, and I'll talk about tracing and then I'll deal with technology generally speaking. With regard to the tracing applications, as we've said, there are several principles that we've put forward that aren't provided for in the Act now. For example, to use applications solely for public health tracing purposes. So there's nothing in the present law that prevents a company to offer a tracing application that would allow that company to use the information collected for commercial purposes. There is just the requirement to obtain consent based on an ambiguous privacy policy. So that's with regard to tracing applications. I'll stop there in case you have other questions you wanted to put to me.
It is, you've spoken in the past about the need for new laws and for us to get together and to talk about. I know that I was on the privacy committee many years ago, and where we were trying to make some changes. So it's important for parliaments to be able to sit to deal with these types of things. And I know that just to speak about what you had mentioned a few days ago, and I'll quote what you said. I believe we have finally reached the point where the question of whether privacy legislation should be amended is behind us. The question before us now is how. So you have mentioned how important it is for government to get onto this so that it has the legal framework to be able to work. So I want to give you an opportunity to emphasize how important getting the laws right and getting them done right away is going to be for Canada's privacy.
Merci. Alors, je vais donner quelques exemples.
Thank you. I'll give you a few examples. Coming back to tracing applications, I would say that it is probable that a good portion of Canadians could be distrustful, may not trust, have confidence in the way in which the information they would provide would be used. So that's a major issue. If we had a more robust legal framework, it is highly possible, virtually certain, that people would have more confidence in the system and would rely on these applications because they would see the benefits of this for public health and they would be less fearful of violations of their privacy. Moving beyond tracing applications, COVID is such that medical services on the one hand, education services on the other, and there are all sorts of other examples I could provide, are at present delivered virtually, digitally. And I believe that this is a phenomenon that will continue, if not at the same pace. These services that are essential and that with regard to medical services involve confidential information protected by medical practitioners are contained on platforms where the legal obligations are deficient and where individuals would be right in fearing that their confidential information would not be protected. So there are immense advantages if we think about telemedicine or teleeducation. We must protect people's privacy.
And my time is just about up. I certainly wanted to mention, though, that you look at internet reliability, and in rural Canada, it's about 1/11th as reliable as it is in urban Canada. So it makes it very difficult. Thank you very much, Madam Chair.
Thank you very much, MP Dreeshen. Our next round of questions goes to MP Johari. You have the floor for 5 minutes.
Thank you, Madam Chair, and thank you, Mr. Turian. Mr. Turian, on May 7th of this year, the Privacy Commission of Canada and your provincial counterparts and territorial counterparts issued a joint statement which you urge all governments to respect the privacy principles. First of all, let me thank you for the great work that you and your department and your counterparts are doing on this front. And I'd like to ask the question, I understand that the federal government hasn't decided on any contact tracing. Has any of the provinces, your counterparts, decided or are close to any decision on a contact tracing application?
I may be out of date. Certainly, there's an application that has been in place now for some time.
Great, thank you. And I was hoping you'd say that. Okay, so given the fact that Alberta has chosen to proceed with it, can you give us an insight into the alignment of the privacy criteria that we have developed or you have developed with the application features? Does this application meet those privacy requirements?
Alors, la conformité de l'application.
The compliance of the application chosen in Alberta with regard to privacy is being studied by Jill Clayton, my provincial counterpart. So that is waiting for her decision. I would say in summary that there is alignment with regard to the use of that application and some of our principles, namely the opting in aspect. Consent must be given. So that's one of our principles that is being applied. Are all of them applied? I don't know. I will rely on my counterpart's decision.
Alberta, do you know what the adoption rate in that province for that application is?
I'm afraid not.
Okay. So how do you feel that we would be able to achieve an adoption rate of anywhere from 60 to 80% without an opt-out model?
Alors, c'est une excellente question.
That's an excellent question. The adoption rates in various countries are of around 20%. If the application's use were compulsory, there would be ways for people to circumvent this. For example, walk around without your phone on your person. So there must be some opt-in aspect in that context. How would we increase compliance rates or use rates? Well, you would have to put in place conditions favorable to the respect of privacy rights. So a system in which privacy rights would be respected, and there must be transparency as well. Transparency is very important.
I want to go into the ownership of the data. As you know, there are discussion around centralized and decentralized model. What are your thoughts around the ownership of the data and the scope of the data that's being gathered during the COVID-19, during an epidemic, situation, and post? And if you could make it brief, because I have a follow-up question.
Très bien.
Very well. The decentralized systems, generally speaking, better protect privacy. That being said, we're not opposed to certain centralization aspects to the extent that data would be deemed to be necessary by a public health authority, for example, to determine where there's an outbreak.
The deeming of the data being necessary as we are trying to move to the next stage of being able to move into the predictive model that we could help with wave 2 and wave 3. Don't you believe that if we maintain a larger scope of the data as well as maintaining the data much longer, it would give us a much stronger ability to be able to do the analytics that we need to get into that predictive model?
The higher the compliance rate, the better it is for effectiveness and the analysis that we can do of the data. I agree with that. With regard to the duration, well, we're looking here at very sensitive data that normally would not be compiled or retained. So I'm not necessarily in favor of the idea of using this data over a long period of time. Thank you very much. The next round is for Mr. Savard-Tremblay. You have 2.5 minutes.
Vous m'entendez?
Can you hear me? Yes, of course. Thank you, Chair. Thank you, Mr. Commissioner. I have a question. You talked earlier about weaknesses in the legislation, in the Act itself, that there are things in it that could be changed. I'm asking you this. With respect to provincial legislation, could you just refer to provincial legislation to correct the deficiency? While traveling between jurisdictions and countries is something that we cannot dismiss, you do have to have stringent legislation at the federal level, though, and at the provincial levels. Can you say a few more words about the legislative changes that you think should be made? In all jurisdictions, that includes provincial legislation. I think that in federal legislation, it would be a matter of more coordination. Can you perhaps say a few words about that? What we have proposed for some time, in fact, for some years now, is legislative reform at the federal level that we say is rights-oriented. This is one of the principles that underlies what we are doing with our joint declaration with the provincial counterparts. And In general, there are things that are not in the federal legislation, but can be found in some provincial legislation. But provincial legislation as well has to be amended according to my colleagues. So basically, we're talking about in our joint statement something that would have the force of law. A statement, a joint statement. How much time do I have left, Madam Chair? 25 seconds. I think that in 25 seconds, I won't really have the time. I'll do it. Is in a medical matter like COVID, does that data, if you test positive, does it belong to the individual or to the government, to the law? Well, I think the notions of ownership are not really applicable here. It's quite clear that privacy provides control over the individual, not just with respect to property, but also health information. I'm so sorry, Mr. Terrien, but this is all the time we have for this round of questions. Member Massey, you have 2.5 minutes.
I want to go back to a little bit here on process. Early on, I was approached by a company that does contact tracing through malls and shopping. And the way that it works is the government set up a process to stream any of those companies interested in doing work with the government through 3 portals of Industry Canada. It's actually a good model and done some great work, actually. Now, I don't know what happened with regards to that file, but I understand is that there really hasn't been any follow-up with yourself or your office. So this has been more than a month now, closer to 2 months, and there hasn't been, I want to confirm this, any robust discussion about creating an app or maybe potentially screening any potential partnership with a company for a public-private partnership, because I think that would be part of what we need satisfaction with to ensure Canadians' privacy, is that the company we're doing a partnership with would also go through a screen.
You're talking about a contact tracing app?
Yes, please. Yeah.
Alors, la seule application de traçage pour laquelle on a été consulté.
The only one that we have been consulted in detail about was Esila in Montreal. The federal government doesn't have to consult us, of course. It's not mandatory. Maybe, perhaps the government has decided not to do business with the company ABC, but so our service is one we offer to the government, and it can be accepted or not by the government.
Professional, more professional feelings about either a non-government agency like China or a private equity fund where we have no idea who owns the company working with Canadians' private data versus that of a Canadian company with a Canadian app.
C'est sûr que si on parle.
Well, of course, there are deficiencies in the Act, and if the data are to be correctly protected, given that situation, the trust, the confidence and reliability of the company that we deal with is absolutely of utmost importance. If you have less trust, well, you wouldn't use it.
We have for that first panel. With that, I will thank the Privacy Commissioner. Merci beaucoup pour votre présence.
To the Privacy Commissioner, thank you for being here. Thank you for your evidence.
Panel. Thank you. One moment.
Merci beaucoup.
Thank you.
With us for the second panel, we have Professor Teresa Scassa, the Canadian Research Chair in Information Law and Policy at the University of Ottawa, as well as Mr. Michael Bryan from Canadian Civil Liberties Association. We will start with presentations for 5 minutes each, followed by rounds of questions. Just to remind the witnesses that if you see the yellow card, that means you have 30 seconds remaining. The red card means that your time is up. With that, I will turn the floor over to Professor Scassa. You have 5 minutes.
Thank you, Madam Chair and committee members, for the opportunity to address this committee on privacy in Canada's COVID-19 response. We're currently in a situation in which Canadians are very vulnerable economically, socially, and in terms of their physical and mental health. Canadians know that sacrifices are necessary to address this crisis and have already made sacrifices of different magnitudes. Most Canadians accept that this is necessary to save lives and begin to return to normal. They accept that some degree of privacy may need to be sacrificed in some contexts, but there is no binary choice between privacy and no privacy. Instead, there must be a careful balancing of privacy with other public interests. There are two overarching privacy concerns when it comes to Canada's response to the pandemic. The first is that there's a risk that poorly thought out collection, use, or disclosure of personal information will create privacy and security vulnerabilities with little real benefit or with benefits disproportionate to risks and harms. The second is that the pandemic may lead to the introduction of data gathering or processing technologies that will create a new normal, leading to even greater inroads on privacy, dignity, and autonomy. Importantly, surveillance often has the most significant adverse impacts on the most vulnerable in our society. The pandemic context raises a broad range of privacy issues, from government or law enforcement access to location and personal health information to contact tracing apps and beyond. As we begin the return to normal, we will also see issues of workplace surveillance as well as tracking tools and technologies used to help determine who gets into stores, who receives services, or who gets on airplanes. Personal health information, generally considered to be among our most sensitive information, may become a currency we're required to use in order to carry out ordinary daily activities. Since time is limited, I'd like to tease out three main themes. A first theme is trust. Trust is referenced in the Digital Charter and is essential when asking Canadians to share personal information with government. But trust is complicated by a pandemic context in which issues evolve rapidly and are often unprecedented. One thing that trust requires is transparency, and governments have struggled with transparency, whether it's with respect to sharing data that models the spread of COVID-19 with the public, or, as was the case with Alberta, launching a contact tracing app without releasing the privacy impact assessment. Transparency is essential to trust. A second theme is necessity and proportionality. The Privacy Commissioner of Canada, along with his provincial and territorial counterparts, supports an approach to privacy based on necessity and proportionality. This is derived from the human rights context. Necessity and proportionality provide a robust analytical framework for balancing privacy rights against other public interests and should already be part of an amended Privacy Act. The importance of this approach cannot be overemphasized. We are in a data-driven society. It's easy to become enthused about technological solutions, and innovators promise that data analytics, including AI, can solve many of our problems. We need to remember that while technology can provide astonishing benefits, there is already a long history of poorly designed, poorly implemented, and often rushed technological solutions that have created significant risks and harms. Novel technological solutions often fail. This is becoming a reality, for example, with many recently launched national contact tracing apps. Rushed, flawed schemes to harvest personal data, even if for laudable goals, will erode trust at best and cause harm at worst. This is why clear guidelines, such as those developed by the commissioners, are crucial. There should be an emphasis on purpose and time-limited solutions that minimize privacy impacts. A third theme is human rights. Privacy is closely tied to human rights, but this relationship is increasingly complex in a data-driven society. Privacy laws govern data collection, use, and disclosure, and it's increasingly common for data uses to have significant impacts on human rights and civil liberties, including the freedom of association, freedom of speech, and the right to be free from discrimination. Until recently, public conversations about contact tracing have been predominantly about government-adopted apps to deal with public health and disease tracking. As businesses reopen and people go back to work, the conversation will shift to contact tracing and disease monitoring in the private sector, including the possible use of so-called immunity passports. We will see workplace surveillance technologies as well as technologies that might be used to limit who can enter retail stores, who can access services, who can get on airplanes, and so on. While there are obviously serious public health and safety issues here, as well as issues important to economic recovery and the ability of people to return to work, there is also significant potential for harm, abuse, and injustice. Much of this private sector surveillance will be in areas under provincial jurisdiction, but by no means all of it. The federal government must play a leadership role in setting standards and imposing limitations. And I'll end my remarks here, and I look forward to your questions.
Thank you very much, Professor Scassa. Our next presentation is by Mr. Bryant. You have the floor for 5 minutes.
Merci beaucoup. Bonjour, Madame la Présidente. Merci à tous pour venir cet midi. You will be glad to hear.
Thank you for being here this afternoon.
You'll be glad to hear it anyways. They're bilingual, I'm obviously not. I've provided some speaking notes and what I hope all the committee members have, and if they don't, I'll send another copy to the clerk, is a letter that myself and Brenda McPhail of the Canadian Civil Liberties Association wrote to the Prime Minister and First Ministers on April the 20th, and we've set out a set of principles for what would apply not to private sector apps per se, or private sector technology and contact tracing per se, but to any requirement, provincial or federal law, that would mandate the use of some technology. That's where it, and that may hopefully be a very narrow category, but that's where, as lawmakers, we feel that that there's a process and some principles that apply. We may discuss them, but it's listed there in that letter. It's a set of 9 principles. I want to start with jurisdiction and make a pitch for there being a national perspective on this. The point of Confederation in 1867 was that we would be able to do more together than we could apart. That is being tested during this emergency management as for federalist reasons. I think rightly, the provinces are playing the role and territories are playing the role they ought to play. However, there is a role for parliamentarians. There is, and exactly what that role is, other than the economic relief that is being promised, is for the something that this committee ought to address. And I believe that having some basic standards, human rights standards, and some very basic goals for technology-assisted efforts to tackle COVID would be an appropriate role for parliamentarians to play. A practical consideration, and one that I think to end up being the sad truth. I wish it weren't so, but I don't think that these systems are going to work in 2020 anyways. I think that there's a very real chance that the technological systems that we're talking about today will simply not prove practical in real world conditions. Their accuracy rate may be just too low, and the complexity of human interactions just too high because it renders too many false alarms. Secondly, I think it's very vital that we be able to take a step back and recognize that contact tracing application on its own, it does nothing to stem the spread of COVID. Nothing. It's useful only if those who learn of possible exposure to COVID are able to do something about it. Get tested, get counseling, get treatment, or take measures like self-isolation. But if those services aren't available, that testing isn't available, if it's not possible that somebody's going to self-quarantine without going into bankruptcy, because it's then these technological ideas are useless. And the advice that encourages self-isolation is implausible if at a certain point people can't do it, and they won't do it, as was suggested previously. Furthermore, I'm going to say in my 5 minutes that the thinking through of what proportionality looks like after necessity is established is important. And proportionality means looking at other less intrusive means of getting at what you're trying to get at. So to start out with mandatory adoption of a contact tracing app with a serious fine attached to failure to download the app would never be proportionate in 2020, because the efforts of undertaking this exercise with less intrusive means has to be established first. Lastly, the United Kingdom just released their app this week. They weren't prepared properly, and it was a disaster. It was a complete disaster and an embarrassment to the country. And I'd encourage us to get everything lined up first and the protections lined up first before the app started. Thank you.
Thank you very much, Mr. Bryant. And we'll now go to our round of questions. Our first round of questions goes to MP Gray. You have the floor for 6 minutes.
Great. Thank you very much, Mr. Bryant, and thank you for your testimony here today. I wanted to start with last week we had Google Canada here at this committee, and as you may know, they're releasing those community mobility reports, which track people's movements from their homes to places like parks and transit, tracking their users' location from their phones. And Google Canada stated that their data is aggregated and anonymized to protect users' privacy, but some data re-identification experts state that location data can never truly be anonymized. Mr. Bryant, would you agree with that assessment?
Yes, the latter assessment, I would. We have expert reports that we filed in the court before Google decided to exit their sibling corporation and CCLA were in litigation over the Quayside project, and we filed a number of expert reports. It's on our website, ccla.org, and we make the case that, in essence, anonymizing or de-identification is an overstatement. That's not what happens. In fact, re-identifying, depending on the particular program, is anywhere from self-evident to easy. And certainly the using the term, I think, anonymizing or de-identifying in itself is misleading.
Well, thank you for that. That is certainly concerning. Google Canada also stated that they did not notify their users that they would be using their data in these mobility reports. Mr. Bryant, do you think that Google Canada should have done so?
Yes, I think people deserve to consent to opt in, and at the very least to be able to opt out. And that the main reason that is happening in Canada is because Canada does not have the equivalent of the EU GDPR. Canada does not have the equivalent of the California privacy law, for example. So that failure of this government to get a modern data privacy regime in place in the however many years they've been in office is an enormous failure, because in fact it took about 10 years for the EU GDPR to get developed and worked out before it was released and done. And we're, as far as I can tell, federally, this committee would know better than anyone, not where we ought to be. And that type of law wouldn't work in the EU. They couldn't do what they're doing in Canada, Google, that is.
Well, and I know that the Canadian Civil Liberties Association discusses the idea of meaningful consent when it comes to things such as contact tracing apps. And Mr. Bryant, do you think that Canada's current privacy laws are adequate enough for these companies using these location data from their users to meet the threshold of meaningful consent?
No.
Well, that says it right there. So I guess that leads to my next question, which has to do with the government considering putting in place contact tracing apps during this pandemic. Some cybersecurity experts are stating that to put these tracing apps in place, that Canada would need new legislation to set boundaries and protect Canada's privacy. Would you agree with this?
I generally advise against legislating on the subject of emergency management during an emergency. That the uncertainty and fear that is present at the time of a pandemic interferes with and disproportionately adversely affects individual rights. And so, in essence, everything ends up being like the U.S. Patriot Act. So under those circumstances, I'm nervous, I should say, about legislating at this time because I don't think that adequate protection for human rights would be found. Be that as it may, nevertheless can be put into place apparently a lot by way of emergency management cabinet orders and council, provincially and federally, and that the powers exist to put those protections in place. So I'm ducking that question a bit, because I'd rather that our privacy laws not be legislated right now in Canada, because I think at the end of it, it would be a mistake and it'd be bad news for civil liberties.
Do we have time for one more, Madam Chair? I think we're going up against the clock here.
45 seconds.
Okay. One last quick question then. Do you think that Canada's current privacy laws are sufficient to protect Canada's data on potentially widely using apps which will track their location and personal data for contact tracing purposes?
No, I don't. But that doesn't mean that something couldn't be put together that provides some temporary protections. But I think that that's a job for parliamentarians to tackle, so that we don't have one set of rights in Alberta and another set of rights in Newfoundland and another in Ontario. I think that this would be an area where we ought to have a national standard and aspire towards that, and that it be one that's superior to those jurisdictions that have little respect for human rights.
Mm-hmm.
Thank you very much. Our next round of questions goes to MP Lambropoulos. You have the floor for 6 minutes.
Thank you, Madam Chair, and I'd like to thank all of our witnesses for being with us today. And my first questions are actually going to go to Professor Scassa. Federal privacy laws have not been really substantially amended since their enactment, and the Privacy Commissioner of Canada noted in a joint statement with his provincial and territorial counterparts that our current laws do not provide an appropriate level of protection to Canadians with regards to their privacy, given the digital environment. He actually mentioned it again today during the first panel in this meeting. Do you agree with the joint statement and the principles that it contains?
Yes, I do. These are laws that were drafted at a time when we collected far less data and did far fewer things with data. They were written for a very different type of environment. We are in a data-driven society. We need laws that are adapted to it.
Absolutely. And what changes to federal policy privacy laws do you think would be beneficial during this crisis or going forward in a future that is increasingly a digital environment?
One of the things that's been raised by so many critics of PIPEDA and is enforcement, that there simply aren't enough teeth in PIPEDA, that there is inadequate enforcement of privacy rights. And so I think that that's one very important area that would have to be looked at.
Okay, thank you. And do you think that COVID-19 has shed light on other gaps that we currently have with regards to our privacy laws?
I think, COVID-19, I think, is a wake-up call in many respects. It's caught us with our privacy pants down, essentially, right? We need to have the digital legal infrastructure in place so that we can respond to situations as they come up. And we find ourselves in the situation with outdated privacy laws for the public sector and for the private sector. And I think that this is a disadvantage.
Okay, thank you very much. And since today we're really here to talk about a contact tracing app that is potentially being developed, what are your thoughts specifically with regards to this contact tracing app, and where do we draw the line between protecting the privacy of Canadians and the greater good of Canada's public health?
Yeah, that's an interesting question because no two contact tracing apps are created equal. There are contact tracing apps that focus on collecting only data about proximity of devices. There are contact tracing apps that also collect GPS data, which could be useful to public health authorities in determining where there are outbreaks. And there are contact tracing apps that are going to ask users to input symptoms and so on, and may use AI to provide analytics to supplement the lack of testing that we have. And so this is a very broad range of data collection. They're very different apps with different goals. And I think talking about contact tracing apps in the abstract is really problematic, and it's very challenging for Canadians. I've seen surveys done asking Canadians if they are in favor or opposed to contact tracing apps, but nobody knows what we're talking about. And I think this is part of the issue of transparency. I mean, I think we have to be very clear about what our goals are, what kind of information we're planning to collect, to serve what purposes, before people can really meaningfully engage with whether or not this is a good thing and something that people want to participate in.
Do you think that at any point it is okay for these apps to be mandatory and not opt-in? And at what point what is that point?
Yeah, well, two things. One is for a general national contact tracing app, I think we've already heard about what the challenges are with making that mandatory. And I think there are serious civil liberties issues with forcing people to carry their cell phones everywhere and have them running these apps in the background. But I think the new wave that I alluded to in my comments, and it's coming very fast, is going to be mandatory contact tracing apps in workplaces. People are going to be going back to workplaces where the employer says you must use this contact tracing app if you want to be part of this workplace. And that may be necessary to preventing major outbreaks of disease or controlling them within workplaces. And we've certainly seen this as an issue, but those apps are likely to be mandatory. And I think that we, in addition to these debates about the national contact tracing app, I think we need to start thinking about what the boundaries and parameters should be for these mandatory workplace apps that are coming.
And I know that Mr. Bryant actually pointed this out earlier, or gave his opinion on this earlier, but do you think that this type of an app or any contact tracing app is an effective way of making sure that we don't spread this type of virus, given specifically, the qualities of COVID-19 and the symptoms that it has, and the way that people can carry it or not and spread the virus?
Effectiveness really depends on what the goals are. And so if the goals are to replace human contact tracing, I don't think it'll be effective. If the goals are to support or supplement it, depending on the design, possibly there'll be some usefulness there. If the goals are to actually collect indirectly data that can be used in analytics for modeling, disease modeling, then maybe there will be some useful data collected, but that's a different message that needs to be sent to Canadians. And so I think that this is, understanding what it is that we're talking about and what the goals are for using such an app are really important.
Okay. Well, I saw the yellow flag, and so I imagine I have less than 20 seconds left. So thank you very much for your time.
Thank you.
Merci beaucoup. Donc,
thank you very much. The next round of questions is for Mr. Lemire. 6 minutes. Thank you so much, Madam Chair. I'm going to begin with Ms. Scassa on principle, because for me, the most important issue is this. Who does the data belong to? And I think that is what we have to elucidate. In a positive test for COVID-19, should that belong to the state, or should that belong to the person who has the medical record?
The question of sort of ownership of data, the language of ownership, I think, can be a little bit problematic or misleading in this context. In the Canadian approach, we've always talked about interests in data. And and we've recognized that there can be multiple interests in data. So a private sector company that collects data has an interest in the data they collect. The individual they collect it from has an interest in that data, and there may be other interests. And it's the same with personal health information. The doctor that collects or the health system has an interest in data collected through the medical system for a variety of purposes, and the individual has an interest in data. The GDPR is a model that pushes us much more towards it strengthens those interests. It doesn't assign ownership of data either, but it does provide for stronger interests on the part of the individual. Right now, I think we're in a data protection framework, particularly at the private sector level, that gives individuals considerably less interest or control in their data than you would see in the European context. But I think in all cases, it's really a matter of interests, and you can have multiple interests in the same data.
Monsieur Bryant, est-ce que selon vous, la donnée d'un cas positif de COVID...
Mr. Bryant, after you, do you think that a COVID positive test information should belong to the person's medical record, to the person, or to the state?
I would argue against it belonging to the state, and at this time, there's no evidence to suggest that, firstly, once having that information, I should say at the outset, I agree with everything Professor Skeza said and will say. I concur with everything she says, and you can hold me to that. The discussion about this turns in part on centralized system versus decentralized. Germany started out with arguing for a centralized system, ended up arguing for a decentralized system, which gave people better control. Gave people control over their information. I think that information about that person belongs to that person. It doesn't belong to the state. The state, as the professor says, may have some interest in it, but we need to start with trusting people. Secondly, the state may play a role in incentivizing people sharing that information, but only once every other means has been exhausted ought the state ever consider trying to take ownership over that information. We talk a lot about mandatory and not mandatory in Canada. It's extraordinary to me that this country has become that, and very little about the incentivizing that can take place that can get even greater compliance. So compliance with the use of the use of these contact tracing apps, compliance with respect to reporting, compliance with respect to self quarantining. All this can, I guess you could try and get people with a stick to do it. I would argue it's going to be ineffective. People won't use it. It'll be avoided. But the alternative is that you provide incentives for that. So, in the United States, the University of Chicago economist talks about how much money would be saved if governments actually paid people to comply, paid people to self-isolate, paid people to get tested every week, for example, or made it available to created some incentive so that when they participate in it, they get some kind of a benefit. It might end up being a lottery, in essence, a pandemic lottery ticket. We're talking about the author of Freakonomics. We're not University of Chicago economists are. I think it's safe to say they can be respected and taken seriously. The idea is to try and internalize the externalities, and we ought to be doing more of that. In allowing people to take that information, to your question, that they own and use it in a way that aligns with what the state wants from that person.
Merci, M. Ryan. C'était effectivement...
Thank you. That was a very complete answer, and it shows me how we as legislators bear great responsibility in this area. We shouldn't be letting private industry settle these issues for us. Marie-Hélène is going to share my time. Mr. Bryant, I know that businesses, when we ask them, where is our data? What do you do with our data? If everything's analyzed, as Ms. Gaza mentioned. And if we legislate specifically on something, what do you think should be done given the context of this pandemic?
I don't want any of my previous comments to suggest that the work to be done on privacy legislation ought not take place. Is that read for me, Madam Chair? So I'm done.
Unfortunately, if you could wrap it up real quick.
Okay. Yes, draft the laws, start debating the laws, make them public, have a conversation with the public about them, but I would not take them to the legislature in the middle of a pandemic.
Thank you. Merci beaucoup. Our next round of questions goes to MP Massé. You have 6 minutes.
Well, thank you, Madam Chair, and again, thank you to the witnesses. And my question will be for both. So where I represent is Windsor, Ontario, and right across from Detroit, Michigan, where there's a significant outbreak there, amongst the highest in the world, really. But, under regular times, when we have international, a movement of, say, for example, I'll use the river that separates the fish. You can tell the fish they're supposed to be on the American side or the Canadian side, but they don't listen. They'll go back and forth. And what I see happening with some of the discussions taking place with contact and data tracing, we have a global pandemic, yet we have very much pockets of contact tracing going on with regards to the attempts to protect personal privacy and as well ensure confidence in the management of the system and so forth. So I'm just wondering if you have any comments about the value of it, given the fact it is a global pandemic. We have people in our own country with such multiple platforms on our cell and our mobile information sharing devices now as it is, and then potentially other factors of foreign visitation, even during the worst of times, is still happening. And then second of all, you also have people of essential workers traveling back and forth. Normally in Windsor here, there's 10,000 trucks a day and 30,000 vehicles. It's down significantly, but it's still in the thousands of vehicles. I'm just curious as to the data that we'll get from this, and given the fact that it seems to be we're compartmentalized amongst different countries. Maybe Mr. Bryant first, and then over next.
Thank you. I confess I'm not sure I understood your question, but I'm going to take my best shot at addressing it. I would agree if I understand you correctly that there are just so many different ways in which the virus is being fed, many of which we don't even know. Some of which, yes, continue to arise from people from other jurisdictions, and much of it, as you mentioned, being found in larger urban centers. And for example, in Ontario, it's more so that Windsor, Toronto, London, and Ottawa continue to have a pandemic crisis. Much of the other province, really not so much. So in that sense, the context in which contact tracing, for example, would be useful and helpful may be quite limited in urban centers, extremely limited. And at this stage, possibly useless. That's not to say that down the line it would not be useful in those regions where there's a very small population, and that's a way in which to keep the virus from spreading at all. The way in which this virus is going to be reduced by way of contact tracing apps in urban centers, there may be a correlation, but I don't know if we'll be able to say, oh, this caused that. On the other hand, in smaller populations, it may be otherwise. I'm going to let the professor take it from here.
Thank you.
Thank you. I was just reading about how Northern Ireland, which is part of the UK, has declined to implement the UK contact tracing app in favor of adopting a solution that's compatible with the Republic of Ireland with whom they share an island, because that's their choice, and they're thinking in terms of where their people are traveling and where their people are moving. I think we started off small for a while. Ottawa Public Health was talking about adopting a contact tracing app at a time when nobody was leaving Ottawa. We were all staying home, and that's where we needed an app. But now we're going to start opening things up, and we need an Ontario app. And when Alberta adopted its app, the pushback, which I think that you are feeling right now as parliamentarians, was we need a national solution, because as soon as we start opening things up, people are going to be traveling across the country. And if you don't have something that works across borders, then it's not going to be particularly useful. And especially, of course, here in Ottawa, we share a border with Quebec and people travel back and forth all the time. So I think as our circumstances change, so does the vision of what we have to deal with. Which has an impact on what technology we adopt. And this is all moving so quickly that I think it's been hard to adapt and respond to it. And again, I'm just going to make the plug for thinking about the next thing, which is workplace employment contact tracing. And I think that this is the big wave that's coming, and I think it's going to be a really important one.
Okay, so that's actually really good. And with that, would it make sense then, either if we are going down this road, I only have a few seconds, so I'll just real quick, to almost again have a specific bond between, or agreement between, the employer and the person, and then the second then to the country and the person, or is it just about the overall country policy? I'll leave it at that because there's no time for you. Sorry.
I don't know if I can respond very quickly. I mean, I think that we're going to have to be looking at workplaces, we're going to be looking at PIPEDA, and we're going to be looking at provincial laws to the extent that they're applicable in Alberta or BC or Quebec. And that's we're going to have to look for solutions. And I don't think there are particularly good ones right now.
Thank you very much. Our next round of questions goes to MP Patzer. You have the floor for 5 minutes.
Thank you, Madam Chair. My first question is going to be for Mr. Bryant, and I'm just looking for a simple yes or no. Is data ownership considered private property?
Is my data my property? I'd say yes, that's my property, but I have a qualification. I know you wanted a yes or no, but you get to ask the questions and I get to give the answer.
Yep, no, that's fine. If you want to give that quick qualification, if you want to do that, just do it quick, if you wouldn't mind.
I just repeat what the professor said about other actors, including having an interest in it, and choices need to be made about who gets that interest. Police would probably like my private data because police like that kind of information. It assists their information. It assists their investigations. But you would want to forbid data leakage outside of the public health context.
Right. Yeah. The reason why I asked it, I'm just concerned because private property isn't really a constitutionally protected element of the Constitution. So, but anyways, I'm going to move on to my next points here. There are already concerns about the freedom of the press in the last couple of years prior to the pandemic. Unfortunately, with Parliament suspended and its powers limited, there's much more of a need for the media to openly follow and question the government's decisions and activities. So are there any barriers or concerning trends for Canadian media to access or challenge the government, especially since lockdowns began?
I mean, there's no question that there's an absence of accountability. For example, I'm concerned that when there are announcements made by government ministers, we'll just talk about the federal government, when announcements or a daily update is provided, how much of that is has legal authority versus how much of it is just the person's opinion. So what I think what would be helpful on these daily updates is, the cabinet has passed the following orders in council. Here's what they are. Here's where you go find them on a website. Now here, let me tell you my personal opinion about things that has no legal authority. But because we don't know what is law and what is not, the rule of law is thrown into question. Accountability is certainly thrown into question, and democracy is not aided by all that. That would be the what comes most urgently to mind that threatens accountability of the executive to the legislature. and the extent to which the legislative members feel shut out by that is something that I guess is for the members to decide how to remedy that.
Yeah, well, thank you for that. Yeah, in recent months, we have seen the federal government play with the idea of shutting down what they consider fake news being spread online regarding COVID-19. However, a few months ago, it seems the government spread some fake news themselves regarding masks, human transmission of the virus, and the origins of the virus. It was all inaccurate. So how damaging would these measures be to the Canadians' freedom of speech, but also for the freedom of the press?
Yeah, we'd argue against any measure by any government or any legislature seeking to in any way chill, let alone censor people in terms of their freedom of expression.
So what are the unintended negative consequences such measures could create?
Well, who has a monopoly over the truth? Are we willing to say that the government or a legislature has a monopoly over the truth? No, of course not. So if we can agree that governments don't get to decide what's true and not true, then they can't get the power to decide what information ought to be circulated to others.
Okay, and this next question, I would like you, Mr. Bryant, to answer first, and then Mrs. Scassa, if you wouldn't mind answering as well. So last week, we heard a witness from a private company describe their work with provincial health databases as creating, and I quote, a single source of truth, end quote. So do you have any concerns about how governments and companies are planning to collect and manage data?
Yes, but you know what? I think I'm going to let Professor Case go first, since I took all the last few questions.
There with 30. Yes, I always have concerns about how data collection and use is going to take place, especially as we move into a time of big data analytics and artificial intelligence, because the uses can go beyond what we've even imagined before. And so I do think we need to have strong privacy legislation in place and strong accountability and oversight.
Thank you.
Thank you very much. Our next round of questions goes to MP Assassi. You have the floor for 5 minutes.
Thank you, Madam Chair, and thank you to the witnesses for appearing before our committee today. Now, as you both may have heard, we just heard that the only province that has actually launched a tracing app, Alberta, is still waiting to hear from their privacy commissioner as to whether that app actually lives up to the standards that were set out in the joint statement that was released on May 7th. So I just took a look at the website of the Alberta Privacy Commissioner, and it says privacy impact assessments can take up to a year. So, you know, in reality, I'm kind of astounded, because if we take the joint statement that was released by the provincial and federal privacy commissioners, did they mean to just provide us with some yardsticks, but then recognizing full well that it would take many, many months before a government could go there and ensure that all those safeguards are there? What is the process that you would recommend a government adhere to? If I could start off with Professor Scassa.
Yes. My understanding is that there was already a privacy impact assessment that was carried out on the Alberta app. And that's what the Privacy Commissioner in Alberta is reviewing. And she is, I think, having discussions with the Alberta government. And so I think that's why we haven't yet had a verdict. She has some concerns that she wanted to raise based on the PIA. The Australian app that was released at the same time as its privacy impact assessment. It's a long, comprehensive document that they posted on their website as well. So it is possible to have a privacy impact assessment done quickly. And these PIA, the Australian PIA, for example, flagged some serious issues which the legislature in the Parliament in Australia is now considering and taking into account and looking at legislation. So where there's a need and a sense of urgency, things can move more quickly. And I know that the Privacy Commissioner talked about, talking with Mila about their app and providing advice and consultation with Mila. So there are ways for things to happen quickly. Not everything is going to be on slow time, but so I have confidence that that work can be done and can be done quickly to improve privacy with these types of apps, even in a crisis.
Mr. Bryant, would you like to add anything to that?
Yes, I mean, there's. I think that there's a difference between a final assessment on the one hand and getting some feedback from a privacy commissioner on the other hand. I know that the federal privacy commissioner would welcome an opportunity to appear before this committee or appear before anybody that asks them to come in and provide a preliminary set of opinions. I mean, where a privacy commissioner says, look, I just need some more information, they can provide that information. But more often than not, they're able to say, look, if this, then that, and so on. So the idea that, I mean, I think that that answer was in part typical of that privacy commissioner. And secondly, was also driven by the fact that if you're seeking a final answer, I'm not going to have one for a while, but that doesn't mean that we can't get preliminary answers.
Thank you for that. Now, if I could return to Professor Scassa, in your opening remarks, you flagged the issue of workplace privacy. That is actually one of those issues that we very, very seldom hear about in the papers. Could you elaborate on that? What are the things we should be very much concerned about?
Well, my understanding is that there are discussions taking place in Canada and in other countries as well about, especially where you have a large workforce, about how people are going to be able to return to the workplace and be safe. And so in that context, they are designing, developing, and looking to implement contact tracing apps within the workplace that will basically monitor where people are within the workplace, who they interact with, where they move about, what their patterns of movement are within the workplace, so that if there is an outbreak of COVID-19 or if an employee is diagnosed with COVID-19, then other employees can be notified and appropriate measures can be taken. And so you can, on the one hand, understand how important that is in getting people back to work and keeping people safe. At the same time, that's a very significant level of surveillance. And so I think it raises privacy issues that we need to be thinking very seriously about when we put protections and balancing factors in place.
Thank you. Mr. Bryant, did you want to? Actually, I'm out of time. Thank you.
Sorry, MP Assassi. Our next round of questions goes to MP Rempel-Garner. You have the floor for 5 minutes.
Thank you, Madam Chair. My first question is to Mr. Bryant. You raised earlier the GDPR as well as the CCPA, which I think are two very important pieces of global best practice with regard to data. I know that I think it's Article 20 of the GDPR. It speaks to the right to data portability, and the CCPA actually allows people to request that their data be deleted or opt out of the selling of their data. In those with that being best practice, do you think that it would be beneficial to Canadians to have that type of a data ownership regime, for lack of a better term, ported into law in Canada? You're on mute, sir.
I'm trying to unmute. Here we go. Yes. Yes, I do.
Thank you. Thank you so much. And just to build off my colleague, Mr. Patzer's, as well as Mr. Lemaire's question, do you think that if we enshrined a right or an acknowledgement of personal data ownership, like right now, I think that there's a perception that, due to onerous terms and services, that data or the productive value of data is owned by, let's say, big data corps right now. If we enshrine the right of personal data ownership as a principle or a starting point to build a new privacy framework in Canada, that would be helpful for Canadians.
I'm not sure, and the reason I'm not sure, I'm not able to answer yes or no, is because I think it just depends on what's done with that information. If somebody can access the information that I supposedly own, then that doesn't say much for my ownership rights. I think sure. the issue is more about the presumptions, and so the presumption that it is private information, I think, ought to be the starting point, and then it's up to third parties and the state to make the case for access to that information. I think that's the best way I could answer the question.
It's very helpful. So, Mr. Bryant, I've been a parliamentarian for several years now, and it's a learning experience. I've been on both sides of the aisle. And what I've noticed in my tenure is that over this period, I think that there has been a big centralization of power within PMO. And also, I do question the rights and the ability of parliamentarians under current operating situations. And what's happened in the last several months really concerns me as a parliamentarian and somebody who represents, over 80,000 electors. So I just wanted your thoughts. There's a couple of headlines that really disturbed me. First of all, one was in the Globe and Mail. Health Minister had you stops Dr. Theresa Tam from answering questions about Canada's emerging stockpile of PPE. Also, my understanding is the federal estimates, which are going to be $150 billion-ish of new spending, will only have 4 hours of debate. I know that one of the things that your organization does is protect the right to vote, and I have a right to vote on behalf of many of my constituents. Are you concerned about the state of democracy and civil liberties with regard to how Parliament has been operating through this crisis? And what are your recommendations to us on that in the same?
As I said, I just repeat what I said before about accountability and some clarity and transparency with respect to what the government is doing when it's considering a particular order, what the timeline is for that executive order, what the executive is doing at any given time, and when a decision has been made by cabinet, releasing that immediately and being explicit about it, not putting it in the can, then getting the communications ready and then making it available to the public.
I just have a few seconds left here. It's my understanding that the government has used an order in council to put forward a confiscation regime for property of law-abiding Canadians. Do you think that's acceptable during a pandemic?
I need to know more specifics about it, but I'd say it has to be authorized by legislation, and if it's not authorized by legislation, then it would be without jurisdiction.
Thank you.
Thank you very much. Our next round of questions goes to MP Erskine Smith. You have the floor for 5 minutes.
Thanks very much. I want to start, Professor Skaza. I normally agree with everything you say. And in this case, I agree with almost everything you say. But my one challenge is this. And I think I'm probably speaking into a bit of a void here because I don't think we're going to get to a place where these applications are as effective as they maybe could be. But one challenge in the way of that is, in fact, this idea of requiring opt-in systems. And so if we had, and I know you are absolutely right with respect to very different tracing applications, and so if we look to a decentralized system like the DP3T standard, if we look to using Bluetooth rather than, which is more accurate than using GPS data, if we have a data governance framework in place that respects every other principle on purpose limitation, that information will be deleted at the end of this pandemic, and there's strong oversight from privacy commissioners or privacy advocates like yourself. If it is true, and this may not be true, but if it is true, and there is some research out of Oxford that it is, that a 60% threshold or more or higher an adoption rate is required for this to really have an impact and be successful. And if we could save lives as a result of that, why is an opt-out system so important, and is it not a balance, and are we drawing the lines even before we get to that important question of what is effective overall and where the balance should be struck? Or are we just saying right from the get-go we can't even have this conversation because it should just be opt-in?
Yeah, I think that's a really interesting question to unpack, and I have trouble separating my own skepticism about the technology from the issue of whether it should be mandatory or not. For example, a lot of these technologies, depending on the design and depending on which one it is, depend on effectiveness on people being tested for COVID-19. right? And if you're in a context where not everybody's being tested and tests take 5 days to get the results, and then these apps are going to be minimally effective. They may be
I agree with
useful
that.
in
So let's
some
imagine a world where we
circumstances.
ramp up testing capacity to such a degree that there is a role for them to play. And if there is a role for them to play, and adoption rates of 20% are, we know, not even worth going down that road. They're just not going to be significantly effective. Let's double down on human resources, and we should do that anyway. I agree. But if we can get to a 60% threshold, a 70% threshold by having an opt-out system, which still preserves an individual's choice who truly cares, wouldn't that make more sense? All else being true. And I recognize a lot of contingencies here about the data governance framework, the design of the tracing application. But if everything else is privacy preserving in every other way, is there any give on that particular issue?
Yeah, I think it's hard. I think it's hard because, in a sense, you almost create this context which is not a realistic context in which we live in. And then you've got people who don't have phones, and you've got people who don't have phones that are of the right model or operating system, and you have people who have perceptual disabilities, and you may have difficulty for some Canadians in the English or French language literacy levels necessary to use the app. So you have a number of people who are going to be excluded in any event. And so I think that in that context, mandatory obligatory is problematic. The other issue is the civil liberties issue of making a form of data collection about location, contacts, and personal health information mandatory. And I think that once you set a precedent for saying, though
I've suggested opt-out, right, which is different than mandatory, and still preserves choice in a significant way, and I think would strike a better balance overall. But it requires a lot of other contingencies to be put in place. Mr. Bryant, you were speaking to the importance of freedom of speech. Of course, truth is important too. And when we look to social media companies, which are private actors and certainly have every right to downgrade content that is inaccurate and false and to highlight reliable sources, you wouldn't take any issue with broadcasting standards councils and other decisions like that would focus on and support truth and standards in the dissemination of information, would you?
I'm all for truth, if that's what you're asking. And our concern is primarily with censorship.
Right. I do note, of course, that if you say something false and it harms another person's reputation, of course, I am restricted in saying that. So we do have censorship in a significant way in all sorts of contexts. But would you be opposed to the idea of social media broadcast or social media councils in terms of the ethics of the information that they are effectively pushing forward as algorithms are replacing editors?
I would need to know more about it. I mean, we're the CCLA, so we have the luxury of being able to be hardline on free speech that you don't have pragmatically. So I think I better leave it at that.
Thanks very much.
Thank you very much. Notre prochain tour.
And the next round is for Mr. Savard Tremblay, 2.5 minutes. Thank you to both witnesses for your presentations. I would like to ask you, because earlier with the commissioner, the privacy commissioner, I put a question. I'd like to put it to you, but somewhat differently. With regard to the legislation that might be enforced, might we not be able to specifically target who the data belongs to? In other words, might we be able to decide what we accept to share on the one hand, and with regard to ownership of the data, if there is a breach, if there's a misuse of the data against the will of the individual, might there be serious consequences like we see in some European countries, for example?
Professor, the only thing I'll say is this. I think that control over the data is a more important question than ownership of the data. And I'm not saying that the ownership is irrelevant, but I think for the purposes of this, the topic at hand, the issue is really about control and not about ownership. But that's all I have to say, other than repeating myself with respect to the different interests that are at stake and where, I think that some bottom lines would need to be set, for example, around data leakage to police and other investigation. institutions or agencies. They should not be getting what amount to public health data under any circumstances. Professor, what do you say?
Okay, sorry. I mean, I think that control is the issue, and right now our privacy laws are weak in comparison to, for example, the GDPR in terms of the rights of control that they give to individuals, and they're also weak in terms of the enforcement if there are breaches of those rights. So, so control is the rights of control are tremendously important, and I think we have work to do there.
Donc, pour vous aussi, selon vous, la question.
So the issue of ownership for you too is secondary when compared with control?
Ownership is misleading. I mean, it's misleading and it's a distraction because there are these multiple competing interests. A company or an organization, an entity that has collected data has an interest in that data, as does the individual from whom it's collected. And so to start talking about ownership in that context is meaningful. It's about rights of control.
Merci beaucoup. Thank you very much, Professor.
Thank you very much.
Round of questions. We'll go to MP Massey. You have 2.5 minutes.
Thank you, and I'll go to Professor Scassa first and then to Mr. Bryant. Professor, I proposed a digital bill of rights that would enshrine basically your physical rights to be almost the essence of your digital rights. Without getting into the details in that, is that something that we should have as a defining principle or at least a benchmark that then we could actually have protected by the Privacy Commissioner, the Competition Bureau, and other different public agencies that rule on whether or not our information is abused, misused, and then having it modernized to be protected for both in Canada, but also too for international agreements. That's the concept. It's more robust than that, but the essence of it is that your physical rights are replicated in your digital rights.
Yeah, that's an interesting concept, and I have to confess it's not one that I've thought a lot about. So I'm not sure. I don't want to waste your 2 minutes hemming and hawing and
okay,
thinking
no
about
worries.
it. But it's an interesting concept.
Okay, Mr. Bryant, do you have any comments on that?
I think I'd better undertake to have CCLA review it and get back to you with a proper answer rather than providing a bunch of qualifications in your 2 minutes.
No, that's fair. It's we've been working that for a while. Real quickly, then my last quick question to both Professor Scassa to start, then to you, Mr. Bryant, is do we need to have at the end of the day international treaties as well to deal with consistency of our data use and management as part of our trade negotiations?
I think that we do need to, we're getting to a point where we do need to have international standards because we're constantly running up against, for example, very low thresholds for data protection that are below our own with respect to US companies, which cause enormous problems. But how we will get a consensus internationally and whether it will put us above or below the level of protection that we currently have is anybody's guess. But we do need to have some sort of international privacy consensus.
I think we need to have a national consensus and we need some national laws. We need to update the data laws. I'm sure you don't disagree with that, but I'm going to put my emphasis on that. The international treaties is out of my jurisdiction.
Thank you very much. And that is all the time we have for today. I really want to thank everyone for their patience and flexibility in terms of extending the time we had today. And with that, I will call this meeting adjourned. Thank you very much.
Thank you.
Thank
Teresa,
you.
thank you. Bye-bye.
Thank you. Thank you very much.